All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to the North Carolina Court of Appeals. I'm Judge John Arrowood, and this to my right is Judge Fred Gore. To my left is Judge Jefferson Griffin. We have one case on for argument today, State versus Waters, and I will hear from the appellant if you're ready. And do you want to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 10
And have you already?
I have, Your Honor. May it please the court. My name is Amanda Zimmer. I'm an assistant appellate defender, and I represent William Waters. I'd like to reserve 10 minutes for rebuttal. Mr. Waters carried his M&P shield every day, so he noticed when it went missing. Daniels took the gun without permission. Mr. Waters wanted it back. An argument broke out over the gun and escalated to a fight. This case involves questions about instructions on 3 affirmative defenses: self-defense, detention of an offender by a private person, and claim of right. The concepts surrounding these defenses are both distinct and related. They are also dependent on the facts. The jury was never—
Some of them were dependent upon what the statute allows, and the last one you said, I don't find any allowance for it in the statute. Where do you find that?
There is no statute addressing claim of right. That defense comes from this court's case law.
And have we ever had it in this type of a situation?
No, Your Honor, I cannot find an analogous situation. The jury was never told that if Mr. Waters had the right to detain Daniels or the right to retrieve his own property, he had a legal excuse that would mean he was not the aggressor.
Well, does this mean he had the right to chase him from his property across several other property lines, get in a tussle with him, and then shoot him 14 times? Or 11 to 14 times? You say we need the oral argument to consider this, but we do have a video that shows a lot of this, which the jury saw. Isn't that correct?
Yes, Your Honor.
And am I correct that he did shoot him 14 times or 11 times?
He either shot him 11 times with 14 wounds. The exact number was sort of disputed at trial. So I don't concede that he shot him 14 times. I believe it was 11 times, but the evidence on that was sort of confusing. Okay. But your question brings me right into the first instruction that Mr. Waters requested, which was on the detention of an offender. And 15A 404B specifically allows a person to detain another person if he has probable cause to believe that the person detained had committed a felony or crime involving the theft of property in his presence. Mr. Waters—
where was the theft in his presence?
I don't think the theft had to be in his presence.
Well, you just said the theft in his presence.
The statute specifically says theft. It also says a felony, and a crime involving theft. Possession of stolen goods would be a crime involving theft. So it's not the theft that necessarily occurred in his presence. It's the possession of the stolen goods being both a felony and a crime related to theft.
So I guess, counsel, looking at that, there's a requirement of the reasonableness of the probable cause, I believe. Speak on that as far as the reasonableness of the probable cause of the fact, because I know you touched on some of these are fact specific, and the facts that kind of lead us to eventually, potentially, maybe having the gun in his hand, but there was a lot that transpired prior to that. Get me to the reasonable suspension or the reasonableness therein, because the fidgeting of the waistband and all that, I'm having a problem finding the reasonableness of.
Yes, Your Honor. And first, I'd like to start with reminding the court that probable cause is not certainty.
But it's more than a reasonable suspicion, isn't it?
It is more than a reasonable suspicion. But the United States Supreme Court has said it's—
Refresh me about the recollection of the facts here. He found his testimony was that he found a magazine in the guy's duffel bag. Is that right?
That is correct.
To the arms that he said was missing. And while he found that, the decedent was not at the house, and in fact had been away from the house. Isn't that correct?
He had been away from the house that morning.
and he had come back to the house.
So at the time that Mr. Waters finds the gun, he knows that the gun has been missing for over a day.
He doesn't find the gun, he finds
Sorry,
the
he
magazine.
finds the magazine, which is
I guess I would say, did he call the police or anything when he found the gun missing, or did not find the gun?
no, he did not call the police. He asked the people staying with him about the gun, if they had it, and said if it doesn't turn up, he is going to call the police. I think we have to keep in mind that these people all knew each other. They're friendly. He knows that Daniels has a pending habitual felon charge. He knows that Daniels has prior drug convictions. He doesn't call the police probably because he doesn't want to get his friend in trouble, but he wants his gun back. So he asks, do you guys have it? And when it doesn't turn up, then he starts looking more aggressively for it. He goes
Well,
through,
I mean, if he thought, wouldn't it go into the reasonableness analysis to want to say that, you know, the person who stole the weapon was dangerous? I mean, if he's not dangerous, then what's the exigency? Why does he need to pursue this so quickly to take the firearm back?
I think that's where Mr. Daniels' conduct comes into the analysis. When he gets to Mr. Waters' house that day, he does things that are strange. He goes to a door that's not used, and he immediately gets into a fight with Parker, who's also at the house. Mr. Waters is drawn outside by his other friend, Landon, yelling to him that they're fighting. So there's already this behavior by Mr. Daniels that's odd. He comes up to a door that's not used. When Mr. Waters gets outside, he says he's acting strangely. He's yelling. There's discussion going on. So this is
How does that give him probable cause to believe that he has this weapon on him and he's trying to detect possession of stolen property? How does that give him probable cause?
Right. I think, again, going to the fact that he's acting strangely, he's behaving oddly, and then he starts pulling out his waistband. And where do people commonly hide handguns? In holsters on their waistbands. So this behavior, combined with all this other stuff, is what brings us to the level of probable cause that he has the gun on him. The magazine helps show that he's the one that took the gun.
All right, so say if that's, you know, in a capsule by itself right there. When the decedent flees, the reasonableness, get me to the reasonableness of the pursuit versus staying put and engaging with law enforcement at that point. Get me how that reasonableness continues past these other property lines and through the neighborhood. Get me where that reasonableness continues.
Right. So at the point at which Daniels starts to leave Mr. Waters' property, he's trying to keep them there. He's asking him about the gun. He's saying, keep your hands away from your waist. Stop messing around. He's saying all these things to try to get him to stay there. And so he follows him.
But once he leaves, what gives him the right to pursue him with a gun, chasing him with the gun? And the guy says he's trying to kill me as he goes through the rest of these videos that we see.
Right, he does say that, but Mr. Waters does not shoot him. He continues to yell for him to stop.
Well, he doesn't shoot him until later, but he
shoots him after Daniels puts a gun in his face.
I've seen the video. I'm not sure that we see a gun in anyone's face.
I will give you that the video is not completely clear on the point, but that's Mr. Waters' testimony, which for purposes of the instruction has to be taken as true. So it's not just the video. We also have Mr. Waters' testimony as he narrated the video. So again, the statute allows for reasonable means to detain him. This is a man acting strangely with what Mr. Waters believes to be his stolen, loaded firearm. And I think it's reasonable under these circumstances to follow him, to say, stop, to give me the gun back.
Well,
stop.
It's not as if the police, if you're trying to detain someone for the police to catch them, he never makes an effort to call the police, does he?
His testimony is he comes out of the house without his cell phone. So when he encounters Miss Sermons, I believe it is, on Everett Road as he's walking, and she says, I'm going to call the police, he says, call the police. When they're in the parking lot and someone else says, I'm calling 911, he says, he yells, call 911. He's not trying, He does not stop and use his cell phone to call 911, but he's not
But he could
taking
have called
actions
the police at any
inconsistent.
time before he walked out of the house, since you say had reasonable belief that this guy had stolen his property and the guy's standing outside.
Until he goes outside, he's not able to observe Daniel's behavior and see him messing with his waistband, hear what he's saying, he's threatening people. None of that happens until Mr. Waters is outside the house.
But he also said he also had belief that he stole it before he ever walked out because of the magazine in the duffel bag, doesn't it?
Yes, Your Honor.
Didn't he say that?
He did say he believed he stole it, but getting into the idea that he had the gun on him, he's not able to tell any of that until he gets outside.
He never saw the gun while the decedent was on his property, did he?
No, he did not.
I guess there's also the question of the gun being physical. And I think the defendant, his own testimony in some of the briefing says he was unsure if Daniels had the firearm with him. So if he was unsure of that, my issue of the reasonableness is the pursuit from the property. If we take everything as you say it on the property, then get me to that reasonableness, because I think we might be a reasonable articulable suspicion, but that's not in the scheme that we have. We're at the probable cause standard. So get me to how that remains reasonable once he leaves the property.
I don't think that Mr. Waters' testimony is ever that he doesn't believe that Mr. Daniels has the gun. He thinks he has it. He says, or at least tell me where it is. So maybe the gun was in his truck. Daniels still took the gun. He was still in possession of stolen goods. But Mr. Waters wasn't sure in that moment if he had the gun on him, but he didn't have to be certain. He just had to reasonably believe that based on practical considerations of everyday life on which reasonable and prudent men act. That's what the United States Supreme Court said for probable cause. We're not talking about legal technicalities. This guy was staying with Mr. Waters. He left his gym bag with his property there. The gun wasn't with the magazine in the gym bag. There wasn't very many places that Daniels could have taken the gun unless it was on his person or in Mr. Waters' truck. In which case, Mr. Waters, again, he wanted the gun back and he wanted to keep Daniels there to tell him where it was.
But now the decedent had driven away and come back, and the vehicle wasn't at the property, was it?
No.
So I'm struggling with the probable cause here. Reasonable suspicion, maybe, but that's not enough. You've got to show probable cause.
I understand, and I think this is sufficient when you factor in all the behavior. The fact that this is somebody he knew, this is somebody who was staying with him, and he comes back and he behaves oddly. He's pulling at his waist. We've got cases where this is the kind of thing that cops consider. How is he behaving? He's behaving strangely, and he's cussing in response. He doesn't stop and say, I don't have your gun. Never once does he turn around and say that. All of these things add up to reasonable suspicion.
Once
Well, they
again,
ain't probable cause,
Probable
right?
cause. I'm sorry.
maybe reasonable
Again,
suspicion, but it's not probable. I would argue to you, or would ask you how it gets to probable cause from reasonable suspicion, other than what you've told us. And we're stopping
Well,
your
and-
argument. I want you to
no,
be
it's
able to.
fine, because I just like to move, I'd like to fast forward then. We know at the point at which Daniels pulls the gun on him in the parking lot, at least at that point, there should be probable cause. He did have the gun, and Mr. Waters certainly knew that once he saw his own gun pointed at him. At that point, he's still trying to de-escalate the situation. He's still saying, put the gun down, it's okay, just put the gun down, you're scaring me, please put the gun down. So at that point, he definitely has probable cause to believe that Daniels has his stolen firearm. And the question revolves around what's reasonable at that point.
So it's your argument that once he sees him with the gun, that it's reasonable for him to shoot him 14 times or 11 times under your view?
Your Honor, I'm not saying it's reasonable for him to shoot him 14 times in the absence of any context for in which that happened. This isn't, even the state said if Mr. Waters had pulled out the gun immediately and shot him 14 times, that would be self-defense. That's what the state argued in its closing argument to the jury. But Mr. Waters still doesn't want to shoot his friend. He wants him to calm down, to put the gun down, and stop acting crazy. Stop threatening him. Stop saying he's going to kill him. Mr. Waters waits, and until Daniel starts to raise that gun, he doesn't fire. So I would contend at the point at which his life was threatened, yes, it's reasonable to shoot someone. And again, these shots happen in like 2 seconds. Yes, Your Honor, because this firearm is a weapon that shoots very quickly. These shots happen in about 2.5 seconds, I think the testimony was. So this isn't bam, bam.
It's not lost on me here that the appellate defender is arguing for a lessened standard for probable cause. You're doing a good job, but it is kind of ironic. But does it change? I mean, where is the prejudice in here? Even if we found that he was entitled to that instruction, when we get to the point where they're basically in a gunfight, I mean, is everything else just a wash, and you're down to just the self-defense issue at that point? Because I mean, at that point, it's just who pulled on who.
No, Your Honor, I don't think it's totally a wash at that point. Because again, I think this detention of offenders can stand alone from self-defense because it has that reasonableness factor built into the statute. It doesn't say reasonable if you follow all the rules of self-defense. So our self-defense rules are technical. There was a lot of instructions on them. So the jury could have been instructed on this and not necessarily had to grapple with the self-defense stuff. But to the extent that it still had to grapple with the self-defense stuff, I think the fact that there is an instruction on aggressor goes directly into this, because if Mr. Waters had a right to try to detain Mr. Daniels, then that's something that the jury could have considered in the aggressor instruction. And we know from the jury's questions that they were confused by the aggressor instruction. They asked to see the instruction in writing. They asked to see Mr. Waters' testimony. They ultimately convict of second degree, not first degree. So I think there's a reasonable possibility that if they had been instructed on detention of an offender, then they would have possibly convicted not of second degree, maybe of voluntary manslaughter, or maybe found him not guilty. I think any of those are reasonably possible given how messy this case was factually.
I guess looking at that argument and doing what we have to do, which is look at the comparable case law, which is not a lot, but the closest that we get is the Antia Kashia. My enunciation is probably off, but I say the Becker because that's the one name I can enunciate in the case. I think Becker was the decedent. How do we, when you would try to analogize those two cases, how do you get to say that that's the case on point when you got two shots in the air and then a third, being the kill shot versus 14, 11, a whole lot at point blank close range? Get me to show me how you use that case, but then you try to convince me not to look at the number of shots being different and the vehicle bearing. And I understand that vehicle was bearing down on that business owner, and I know you're going to say, well, he had a pistol on him, but get me to 14 rounds versus 2 in the air. It's very obvious that that individual was trying to scare. 14 to the chest does not show me scare.
Yes, Your Honor. I understand, and I would reframe the question. The question is, was the defendant in a position where he could use deadly force? If he could fire one shot, he could fire 14. They happen so fast. And in the case that I also cannot pronounce the name of and will refer to as Becker in following the court's lead, in that case, that man had never fired a firearm. So he's sort of shooting wildly, and that's why 2 of the shots go into the air. Here, Mr. Waters...
I take exception to where, because ultimately, if you got a gun and a finger and a trigger, to me, whether you've shot it before or you haven't shot before, I understand contextually how that was. But the point is the intent was obvious from everybody that saw where the rounds went. So that's what I'm asking you to distinguish for me, is not necessarily the mens rea, get me to the actus reus because of how obvious where the shots went.
Right, Your Honor, and I would go back to the question of, was he authorized to use deadly force? And in that case, the court said his actions could be construed as reasonable by the jury, and therefore the instruction should have been given. So even though those shots went astray, even though Mr. Waters shot directly at Mr. Daniels, the question was, could it be reasonable to use deadly force in a situation where you're trying to detain someone? So in that regard, the situation with Mr. Becker is similar to what we have here, and further distinguishable from Wall, where there was absolutely no threat of any kind of physical harm to the cashier when he chased after the girl that had stolen some beer. So that's why I think that that is a little bit different.
We're into your rebuttal time, but I do, and you can talk about this in rebuttal, but I do just have a real question about why it was reasonable for him to chase him through the neighborhood with a gun and then shoot him 11 times, how that gets you any of these instructions. But you can do that during your rebuttal time.
I will address that in my rebuttal. Thank you, Your Honor.
We'll hear from the state.
Thank you, Your Honors, and may it please the court. My name is Zachary Dunn here on behalf of the state. When the defendant, William Waters, suspected that his house guest, Jamie Daniels, had stolen one of his handguns, he confronted him and pointed a different handgun at him. And when Daniels ran away from this threat of deadly force, the defendant did not call law enforcement, but instead pursued Daniels with a loaded firearm pointed at Daniels' back. The incident ended at the Slatestone grocery store, of course, where defendant shot and killed Daniels, shot him 11 times, and I believe I introduced this sort of confusion between 11 and 14, so I do want to correct it. I believe that there were 11 shots fired. However, 3 of the shots went through the victim's arm, through and through, and then into his chest. So there was 11 shots, but 14 injuries. So I believe that's correct, and what was argued at trial.
So Daniels he stole the firearm. I mean, that's uncontested.
I believe that's uncontested, yes. Well, it is uncontested.
Okay, and he had it on his possession in front of Mr. Waters, correct?
At the Slatestone grocery store, yes, but I mean, we need to.
What about at his house?
Not at his, well, he had it in his possession, but the defendant did not know he had it in his possession. He said as much on the stand at trial. This is all from transcript volume 7, 1329 to 1331. On cross-examination, the state asked, you didn't see, and they used the term bumper, that was apparently Mr. Daniels' nickname. You didn't see bumper with a gun at that point in time, meaning at the house. And he says, no, I did not. And then he says, he hadn't seen the gun that Bumper had at that point in time. Is that accurate? As he was chasing Mr. Daniels through all of this neighborhood and into the Slatestone grocery store. He says, that's accurate. And then when asked why he didn't call the police, he said, I thought he would just give me my gun back or tell me where it was at. And this is important, critically important, we believe, for defendant's argument under 15A 404, because, of course, that statute, as we've been talking about today, allows a person to detain another when that person has committed in the presence of the person who is detaining the offender a felony. And so my friend on the other side said, it's perfectly fine if the gun was not on Daniel's person. But that would mean that although the defendant may have been committing, Mr. Daniels may have been committing possession of stolen goods, that would not have been in the defendant's presence. So the only way that the defendant gets to a 15A 404 instruction is if he had probable cause to believe that Daniels had the weapon on his person and in the defendant's presence. And because of defendant's own testimony at trial on cross-examination, where he said he didn't see Daniels have a gun when he first pointed a gun at him at his own house, as he was pointing a gun at him and chasing him through a neighborhood and into the grocery store, and even when he holstered that weapon and started a physical altercation with Daniels, he still didn't see the weapon. And so under those facts, Your Honor, the 15A 404 instruction was not appropriate. As Judge Griffin, you mentioned it's odd for the appellate defender to argue for a lower standard, and it's odd for the state to argue for a higher standard for reasonable or for probable cause. I and certainly people from my office every day recognize that it's a low standard, but it is a substantial chance. It's higher than reasonable suspicion. And when the defendant was asked, he was asked on cross-examination, and the question it was posed as, quote, you really didn't have proof that he had stolen it. And so really, what the defendant's going to say is his probable cause analysis. The state is challenging him, saying, you didn't have any proof. And he says, quote, other than finding this magazine in his property and wherever he was at that morning for over 4 hours at Slatestone. So that was the defendant's probable cause analysis. He claims he had found a magazine in defendant's gym bag, and Daniels had been gone for 4 hours that morning. He doesn't explain how that gets him to probable cause or why he believed that this gun was on Daniels' person. But when we go through a probable cause analysis, we rely on, generally, an officer testifying why he believed there was probable cause. And here, the defendant is telling you he believed that there was probable cause because he found the magazine and Daniels was gone for 4 hours before this murder occurred.
Counsel, address the argument that I think it's somewhere in the brief of the constructive possession, and the recent possession argument, or at least I know the constructive possession argument is in there of the magazine and then obviously connected to the gun. How do you address the constructive possession?
The constructive possession argument, so I believe the argument you're referring to is because the defendant had found one or two magazines that allegedly belonged to this shield, this firearm. That means the defendant had probable cause to believe that the victim, Mr. Daniels, had the firearm on his person. And we just say that under the probable cause standard, that is not enough. Because even assuming and taking as true, which I think we have to when determining whether a jury instruction should have been given, that defendant did in fact find I believe it was one of the two magazines, the extended magazine in Daniels' bag. That does not mean that he has the firearm on his person. Like the appellate defender said, it could have been in the defendant's own truck. It could have been anywhere else. And for this 15A 404 instruction to be given, the defendant must show that the person being detained had committed in his presence a felony. And so he is required to show probable cause, that he had probable cause to believe that Daniels had this firearm on his person. And simply finding this magazine among his possessions does not equal probable cause, Your Honor.
Well, does he have probable cause when he sees the firearm down at the store?
When he sees the firearm at the store, yeah, I mean, at that point he knows that the victim, Mr. Daniels, has his firearm. But then at that point the question becomes, well, is he trying to detain him? And I think the answer there is no. Defendant says that at that point, and the video shows that there was no attempt to grab on to Daniels, anything like that. He says, the defendant testifies, he's talking to Daniels saying, stop, put it down. That's not an attempt to detain. And then the shots, the 11 shots, which make 14 wounds, he says is in self-defense, and explicitly disclaims that those shots were an attempt to detain. So by the time he had that probable cause, he was not attempting to detain. He claims he was using self-defense, although that was either partially or fully rejected by the jury in this case. So we would say yes to Your Honor's direct question. At that point, he may have had probable cause, but at that point, he is not attempting to detain Daniels. I do want to talk about Wall a little bit. It was brought up before, and there, of course, the victim left the store without paying for 2 six-packs of beer. And in that case, the Supreme Court relied on the defendant's testimony that the victim had left the store and was exiting the parking lot when defendant fired the shots, and on that testimony held that once the victim was beyond the defendant's control, the defendant could no longer hold or keep him, detain him. And here we have Daniels being accosted, having a gun pointed at him in defendant's front yard and running away. And so under Wall, once the victim was beyond the defendant's control, the defendant could no longer hold or keep him. He's not allowed to chase after him with a gun. Defendant essentially wants to rewrite Wall to say that once the victim was beyond the defendant's control, the defendant could chase the victim down and attempt to regain control of the victim, but that's not what Wall says. So we would say that the 15A 404, just based on that, once Daniels ran away under Wall, defendant was not permitted to chase after him and attempt to detain him. And I will attempt to say, I think it's Atai Cachet, that's the best I could get. But as has been discussed here, Your Honors, that is a very, very different case. In that case, this court found that 2 of the 3 shots were shot in the air, not that these shots went astray, but that they were shot in the air as warning shots. And there, of course, is no warning shots here. So that would be our argument on the first issue. I do want to switch, unless Your Honors have any further questions on that, onto the claim of right or self-help defense, which I know that these are all kind of intermingled, but I do want to spend some time on that issue. And the defendant contends that the jury should have been instructed that he was entitled to forcibly take personal property back from Daniels, and that if Daniels forcibly resisted, he was entitled to exercise the privilege to meet and repel the force.
And when have we found that in the state, that you have the right? Under what situations have we found that?
So, Your Honors, our appellate courts have found it in the context of armed robbery. That's the JAD case, as well as the Spratt case. And then my friend on the other side cites 2 more cases in her reply brief. It's the White case from our Supreme Court, which is arson. Essentially, you can't be charged with arson for setting your own house on fire. And Young, this court's case from 2009, you cannot be charged with breaking and entering if you are breaking and entering your own house. But this court and our Supreme Court has never extended a claim of right or self-help defense into a defense to murder. And we would ask Your Honors not to extend it in this context. We don't believe that the facts of this case fit a self-help defense instruction. Because under the defendant's own telling of events, as we've kind of discussed here today, defendant did not know that Daniels had his weapon. He says he never saw a weapon. As Daniels was running away, he says Daniels did not have a weapon in his hand. And he only saw the weapon when it was pointed at him. But at that time, as he testifies, he claims acting in self-defense, not to regain his property. So that kind of breaks the chain there, and we would just ask Your Honors to hold that self-help or claim of right is not permissible in a circumstance, in this circumstance where it's trying to be used as a defense to murder.
Well, I would like you to address, the appellant did not raise it in their initial argument, but it's talked about substantially in their brief about the motion, or their motion for appropriate relief, and
the claim about false testimony?
Yes.
I'd be happy to switch to that, Your Honor. So the first thing we would quibble with or disagree with my friend on the other side is the standard to apply on this MAR. I believe it's pronounced NAPU, a NAPU claim. It's not knew or should have known, but it is a knowingly false standard. That's, of course, what NAPU says, and then our Supreme Court followed up with that in 1998 in State versus Call, a knowing standard, not a knew or should have known standard. But on the merits, Your Honor, the defendant would have to show that the prosecution knowingly solicited false testimony or knowingly allowed it to go uncorrected when it appeared. And we're talking about two instances that the defendant claims was false testimony, which is the testimony of Deputy Sitterson and the testimony of Dr. Falls. And Sitterson, so what happened there was a different lieutenant, or a different law enforcement officer, Lieutenant Shackelford, was asked by the district attorney, or the assistant district attorney in this case, to see if further testing could be done on the victim's blood. And so Lieutenant Shackelford goes through the process and emails several people trying to see if this blood could be tested. And then eventually Lieutenant Shackelford emails Dr. Falls and asks him that question. And Dr. Falls responds that he is not sure if the blood was still available, and that Lieutenant Shackelford would have to check with the folks in Raleigh, because Dr. Falls was, I believe, at ECU, so he wasn't in Raleigh. And so the specific testimony that the defendant claims was knowingly false from Deputy Sitterson was his testimony that he did not make a subsequent request for the medical examiner to test the blood for any controlled substances, and that he was not aware of any such request coming from the DA's office. And so this is Deputy Sitterson, not Lieutenant Shackelford, testifying on the stand here. And so it's entirely reasonable, and we think correct, to say that Deputy Sitterson did not know about these emails from Lieutenant Shackelford to various entities. And for the assistant district attorney's part, he, in subsequent emails, which are attached to the MAR, says, apparently I did request this. I have no knowledge of it. I did not remember it at all. And so Sitterson was not providing false testimony, and the ADA simply did not remember even making that request until the results came in, which was 4 days after trial.
And the results that came in was a toxicology report and did show that the decedent had substances in his body which may have caused him to act strangely and those kinds of things. And why is that not material to the self-defense?
Well, that would go into the prejudice prong, which I'm happy to talk about, but in order for this to be a NAPU claim, the defendant would have to prove that this testimony was false, that Deputy Sitterson knew that there was a subsequent request for this testing, and there's no evidence to suggest that he did. If Your Honors think that there should be more evidence, then the proper course would be to dismiss it and allow defendant to pursue this MAR in the trial court. But on that prejudice point, I'm not hiding from it. We have testimony from the defendant claiming that the victim, Daniels, was acting erratically. And the false testimony, the alleged false testimony here, if we get this far, is not that the state had these results during the trial and failed to give them over. The testimony is only that the state asked for this testing to be done, but the testing was not complete at the time of trial. And so defendant has to show that that testimony, even if it was false, would have prejudiced the defense. And he's unable to show that here. But if Your Honors think that more testimony and more evidence needs to come in, of course the correct thing to do would be to dismiss it and allow, without prejudice, to defendant's ability to pursue those claims below. Finally, I do want to, unless there are more questions on the MAR, I do want to talk about the aggressor doctrine and defendants' arguments about that. Your honors are well aware of, and I think we've talked about it here a lot today, of when an instruction must be given, which is if it is correct in itself and supported by the evidence. And defendant claims that because defendant holstered his weapon as he approached the victim at the Slatestone grocery store, that he had withdrew from the fight and that therefore he was not the aggressor. And really,
After he holstered the weapon, did he keep going towards Daniels?
He did, Your Honor. So
And
the
in fact,
video,
there was a fight, was there not, or a scuffle?
exactly, yes,
I
there was,
recall
Your
from
Honor.
the video.
So the defendant, as this video from the Slatestone grocery store, I believe it was State's Exhibit 3, was played, and as defendant enters the frame, he still has the gun out and he's still pointing it at Daniels. He does holster the weapon as he's approaching Daniels, but he keeps his hand, importantly, on the gun in the holster for about 6 seconds, and he lets go of the holster to engage in a physical fight with Daniels. And the defendant claims that in his briefing that he spoke to Daniels, he asked for his shield back, and that Daniels initiated the physical contact with the defendant, not the other way around. But the evidence belies this claim simply because we know that Daniels wanted nothing to do with the defendant. The defendant had just pointed a gun at him, and he's running away from both the defendant and his property and being pursued by the defendant in this case. And so, I mean, if you look at it frame by frame, who touched the other first, it might be Daniels. But we know that Daniels was trying to get away from the defendant, and defendant was trying to engage in a physical altercation. He claims to detain Daniels. But really, what he does at the end of the day is to get in this physical altercation, which lasts for around 37 seconds until Daniels gets away, and he pulls a gun on the defendant. We see this on camera at approximately 1:39 and 51 seconds. And so at that point, crucially, Daniels does not use that weapon. He points it at defendant for around 2 seconds, and then he extends his arm to the ground, and he never pulls it back up because he's shot and killed 28 seconds later. And so to put this in perspective, from defendant holstering his weapon, but keeping his hand on the gun in the holster, approximately 1 minute and 14 seconds elapses from that holstering of the weapon until he shoots Daniels to death 11 times with 14 injuries. And defendant must show that he indicated clearly that he desired to withdraw and terminate the use of force. Simply holstering his weapon under these facts, especially when he holsters the weapon for the intent to get in a physical altercation with Daniels, does not show his clear intent to withdraw and terminate the use of force, which he eventually follows through with by shooting Daniels to death 11 times.
So, counsel, address in the framework of those facts, the argument by the defendant of the unnecessary and confusing language that was added to the self-defense. There's an argument by the defendant that some language was added to the jury instructions that made it confusing. How do you address that?
I struggle to find where that is in the transcript. I'm happy to be told exactly where that confusion come from. I do have the quote. It's transcript volume 8, page 618, and this is what the trial court instructed the jury. I believe I have a quote exactly. It says, the defendant was the aggressor under the law if he, quote, displayed a firearm to Daniels, intending to engage in a fight and intending to use deadly force in that fight, and provoked use of deadly force against himself. We believe that that is a correct instruction on the aggressor doctrine. And so I struggle to find any confusing language. Of course, I'm happy to be told that I'm incorrect.
Well, that is the language that was used in Holloman.
I believe so, Your Honor, and we contend that that is a perfectly reasonable aggressor doctrine instruction, and under the facts of this case, the aggressor doctrine was certainly supported by the evidence. Unless there are any further questions from the panel, we would simply ask Your Honors to affirm or find no error. Thank you.
May it please the court. I'd like to briefly address the MAR and then return to the detention of an offender's statute or instruction, because I believe that's where most of the court's questions were. But on the MAR, there is a second claim in the MAR that the toxicology report was new evidence. That claim is independent from the NAPU claim and doesn't require that Mr. Waters show that that testimony was absolutely false. So that's a second claim that the state just doesn't even address in the motion for appropriate relief.
So on that issue, then I guess then the next discussion would be the prejudice. So address the issue of whether that the failure of that inclusion would be prejudice. Get us to the prejudice for your client.
Right, Your Honor. That is the next question. And I believe that Your Honor's touched on it when you said there's testimony that Daniels is gnashing his teeth, that he's sort of talking incoherently, that he's very skittish, that he's behaving very oddly, like he's under the influence of drugs. Having a toxicology report that backed up Mr. Waters' testimony would have added credibility here to the defense. And because
Well, was there
of that,
any, I'm sorry.
Oh, no, go ahead, Your Honor.
No, finish and I'll ask.
Oh, I say because of that, I do think it's material to the defense, and it would have had it's sort of objective evidence of what Mr. Waters was observing in that moment.
And that leads me to my question, as you say, it would have bolstered his testimony, but there was not any testimony opposite that no, he was acting normally or anything like that. It's not as if the jury had to weigh one versus the other. Is that correct?
Your Honor, there's no testimony to dispute that, but the state's argument was certainly that the defendant was wrong about these things and that they were trying to undercut his credibility. So I do think it's relevant, even though there wasn't direct testimony saying that, Mr. Daniels was perfectly sober and behaving rationally that day.
Can you point me in the record where the state either offers questions or asks those questions of the defendant, or makes the argument in the jury argument that he was acting normally?
At this point, no, I cannot point you directly to anything that says he was acting normally. But, Your Honor, I think Mr. Waters' credibility was undoubtedly at issue in this case, and that was something the jury had to decide in order to resolve everything here. I'd like to just briefly go back to something that the state said regarding Mr. Waters' testimony and his statement that, or at least tell me where the gun is. Again, the evidence for purposes of an affirmative defense has to be taken in the light most favorable to the defendant. The defendant said multiple times he believed that Daniels had his gun and that he had it on his person. At that point, because
a belief does not establish probable cause, does it?
Your Honor, I believe, yes, it does. Under these circumstances, his belief rose to the level of probable cause. He was certain, or pretty close to it, that Daniels had his gun because he kept messing around with his waistband. Why do we do that? In normal conversation, I'm not standing here talking to you doing this. I do that if I'm thinking about the gun I've got on my hip.
Well, counsel,
So if an officer walks down Wilmington Street and he knows that somebody around had stolen a Gatorade from the store, and he sees somebody playing with their pocket, is that probable cause?
I mean, I think if that person matches the description of the person that stole the Gatorade.
All right,
If
well, we got you recorded, so next time you come in here and argue with probable cause, I'm going to break this one back out.
In that case, we'll find a way to distinguish it.
There is some irony of both of them arguing the opposite of they normally do. So let's take it to the actual face-to-face encounter. Let's take out the question. So when the victim does take out the firearm, okay? Mm-hmm. Probable cause exists. Let's no question at that point, okay? Get me to the reasonableness within that short period of time of the conduct of the defendant in what actions he was taking at that point to detain. Get me to because there is the reasonableness of the force. Because there was some force used, but it was pretty extreme. Get me to some reasonableness once he sees the firearm and the discussion of the reasonableness of the force.
Right. So at that point that he sees the firearm, he's still trying to talk to Daniels. He is pushing the gun away. He's kind of pushing him, and Daniels is coming back at him, and he says, poking him in the chest. So there's still
Can
this
you point me where that is? After he has the gun out, can you point me where in the video it is that he's poking him in the chest, and if there's any support for that testimony anywhere in that video?
Your Honor, I cannot say exactly where. It's all happening about the minute, and I believe it's about 1:40, 1:48. I'm not positive of the exact timestamp. But the thing about the video is, this isn't a clear video looking directly at both of them when all of this is happening. There's two trucks parked in the way. So some of what is happening, it's not clear on the video. And that's obvious from the jury's questions to see it zoomed in and from multiple angles. So the video to me is important, but we also have to consider Mr. Waters' testimony, and that's what his testimony was, and there's no evidence to contradict that. And I would
Well, if
contend
the
the video doesn't.
contradicts it, isn't that evidence to contradict it?
I don't believe that the video does contradict it, Your Honor, because at that point there's a truck in the way and you can't completely see what's happening.
Well, I guess again, I'll take it back to my question, regardless of the testimony. Where's the reasonableness of the attempted, or what attempts were there to detain? Let me break it down like that. What reasonable efforts were there to detain once he in fact saw, regardless of what he said, regardless of what was blocked? Give me facts to substantiate the reasonableness of the detention that gets you to that instruction, because I'm not seeing them, and so get me there.
Right. So at that point, Mr. Waters doesn't draw his gun. I think that's significant for his reasonableness in the situation. He doesn't want to shoot Mr. Daniels. He's telling him, okay, you're scaring me. Calm down. Just calm down. Put the gun down. Just kind of calm down.
So
He's
then
trying to de-escalate the situation.
So then Daniels does put the firearm down.
Right. He puts the gun down kind of by his side.
To the side. So
And they're still talking. And Mr. Waters, there is some distance between them at this time. Mr. Waters is still sort of in the mix. But again, he's not right up in his face. He's not pulling a gun on him at that point. And according to his testimony, he's still saying, put down the gun. You kind of calm down. You're scaring me.
And the decedent is over here, behind the truck over here, and your client is over here.
Right.
And your client then pulls out his gun and shoots 11 times.
Right. Yes, Your
So
Honor,
how
but
is that reasonable to detain, or even reasonable in self-defense?
it's reasonable because he has a gun. He has a loaded gun right here by his side. Just like Mr. Waters had access to a loaded weapon, and how fast that happened. It's not a situation like Wall, where the stolen goods is a six-pack of beer. It's a loaded firearm. So even though there's some distancing, it's still an active threat. He has the gun out. He doesn't have it holstered. He doesn't put it back into his waistband and stand with his hands where Mr. Waters can see them. He's still holding that weapon, and according to Mr. Waters, threatening to kill him and his friends. So he's still a very active threat. So the steps that he's taking is he's trying to de-escalate. And he says when Mr. Daniels started to raise his hand, the hand holding the stolen gun, that's when he shot. And given that at that point he's facing the threat of being shot, I think that's reasonable under these circumstances to use deadly force.
Isn't that a question for the jury, though?
Yes, Your Honor, and that's why we contend that the instruction here should have been given. And that question would have went to the jury. That was the issue in the case that I still can't pronounce involving Mr. Becker. So
is that
I
a
think
question? Is that a question for the jury for the detention, or is that a question for the jury on the self-defense claim?
I think it's a question on both, Your Honor, because
But if
They got
we-
self-defense.
Yeah, so you got the self-defense, but if you're not showing the reasonableness in the detention, how can you get? I see the issue for the jury on the self-defense, because whether you disengaged, whether you withdrew, yes, but I'm just not getting there on the reasonableness for the detention when he didn't really give a chance to be detained before he blasted 11 times. That's where the rubber is meeting the road and creating a roadblock for me to be able to get to the reasonableness, because I understand the argument and the reasonable for the self-defense, because he did, there was a loaded gun. Yes, that's not to be, questioned. The question is, what would have happened, or what would he have gotten if he would have allowed more time for detention? And we don't know that, because the reasonableness of just shooting after a couple seconds of it being down to the side didn't allow for a detention.
Your Honor, do you
You
think
may
that-
continue.
Thank you. I would say this is a very fast happening situation. And 20 seconds here in this courtroom feels very different than 20 seconds when there's a gun in play that's just been pointed in your face. So I think you're right, 20 seconds is not a long time, and yet it is a long time. The state argues that in that 20 seconds, Mr. Waters lost his right to use self-defense, and that was in their closing argument. So I think the reasonableness of that detention comes from the fact that he is at least making efforts to de-escalate the situation before resulting to defensive force.
And you did get the argument, you did get the self-defense.
Yes, Your Honor, and we contend that all of this plays into the self-defense for the reasons stated sort of in the opening brief and the reply brief. And I recognize I'm out of time, so I would just ask that you give Mr. Waters a new trial. Thank you.
Thank you. Thanks for the spirited arguments. We have we're going to swear some new lawyers in, so we'll be at ease for, what do you need, 5 or 10 minutes?
Yes, sir. All rise. The court is now in recess.